Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss an important topic, normally which the Gram Panchayats do and against which the Andhra Pradesh High Court has given a judgment. So, Gram Panchayat has no power to go for demolition of a building which is located in Grama Kantam. It is for the revenue authorities or the proper procedure you have to follow. No doubt, GP also, Gram Panchayat Act, they have got powers, but they have to follow the procedure. We will get to know all the details in this particular case. Right. So this case is relating to, please remember, Bhavani MAHILA Trust, BMT, Pedakakani in Guntur district. So whenever you are passing between Guntur and Vijayawada, you will have a site of this Pedakakani village where a very famous Lord Ishwara temple is also located. BMT, Bhavani MAHILA Trust versus State of Andhra Pradesh in WP number 1402 by 2022. You can see the citation in ALD, Andhra Law Editions, ALD 2022 Part 4, page number 37 within brackets CAP. Right. The judgment, so please remember, very good judgment. The plaintiff is in long-standing possession. That means the trust, BMT, Bhavani MAHILA Trust, it is staying or they are having the long-standing possession of the house since 1960. So they are there, they are running their operations under the name of the Mahila Trust. Maybe they may be doing some business or they may be doing some activities like agarbatti manufacturing, all these things. Mahila Trust, yes, it is a part of the empowerment of women. So they have been in possession of the particular house from 1960. Right. The Gram Panchayat issued a notice to them, right, because notice issued to the petitioner, please remember, by the Gram Panchayat, what for? They called upon or they have given orders to vacate the house, please vacate the house, but not eviction, please vacate the house, because they wanted to construct a library from the Gram Panchayat. No doubt, library is a very good purpose. People who have got the sparing time, they can come to the library, they can see the news, they can see the newspapers, and also the students who are preparing for the competitive exams, they can also come to the library, have a latest knowledge of the general observations and things like that. Yes, definitely it's a good purpose. But what happened is, before giving any opportunity, the Gram Panchayat, so they have demolished the house, finish. So actually they have given a notice for the so-called vacation, but not eviction. They said that we want the premises for library. So you vacate. But these people, the plaintiff, that is Bhavani MAHILA Trust, they were not given any opportunity for hearing any objection for the eviction. So this is what they have to do under Rule 4 of Gram Panchayat Rules 2011. And it is also a part of the principles of natural justice, odi alteram partem, means hear the other side. This was not done. No doubt they have demolished. Then at least they have to prepare an inventory by videograph. But no inventory was prepared and approved by the Grama Sabha. So please remember, Rule 3 says if anybody does not vacate the premises in spite of the notice by the Gram Panchayat, yes, they can demolish the same. But they have to prepare an inventory. That was not done. So definitely this demolition of home is in violation of all the procedural safeguards under Gram Panchayat Act and also rules. So no doubt, the disputed land, the land in which the building is located, it is located in Grama Kantam. So demolition of the tile house is beyond the authority of the Gram Panchayat. Entire action is illegal, arbitrary and violative of the rights of the plaintiff, that is Bhavani MAHILA Trust, granted under Article 14 of the Constitution of India, as well as right to property, Article 300A of the Constitution of India. This is what. So that's why even sometimes people come to us and ask for a suggestion. Suppose somebody has taken the house of a rent and it is not known as to where he has gone, he is not paying the money, almost 6 or 7 months is over. It happened in Housing Board Colony, Ongole. Then what we suggest, normally if you go to the police, they say it's only civil matter. So what we would suggest is take 2 Panchayat doors, break open the apartment, then prepare an inventory or videograph of the materials like sofa, kitchen material, something. Keep them in one room or keep them aside. Then you give it to some others for rent. Whenever that person comes, we can say, Arey Baba, you have not given the money. Therefore, we have given it for rent. So these are your properties. Take them if you want. So that is the importance of the inventory. Normally, it is totally against to procedural law. But still, it can be accepted as a formality because you have done it in good faith. That is a diligent way of doing things. But Panchayat authorities, they did not do like that. Ultimately, Honorable High Court of Andhra Pradesh, they have stated that the petitioner is entitled to put back in the same position. The house has to be reconstructed and the removed materials have to be handed out to them. See how bad the Gram Panchayat has to face. No doubt they have got every authority. If they follow the rules and principles, so definitely they would have been successful. But since they did not do it, since they are not given any rules of the so-called chance for the rules of principles of natural justice, and also it is very clearly stated in Rule 3 and Rule 4 of Gram Panchayat Rules 2011, definitely now they are violated and now they have to pay back or they have to construct the house. So please remember, the Gram Panchayat Authority, no doubt, the major Gram Panchayat Authority is a very powerful act because they are public servants, nobody can do anything with them. But still, they have to follow the procedure established by law. If they don't do it, this is the result. So please remember, whenever any house is demolished by the Gram Panchayat authorities, as advocates, please check up that they have followed Rule 3 and Rule 4 of Gram Panchayat rules. Otherwise, definitely you can file a writ petition under Article 14 as well as Article 300A of the Constitution of India. I think you are thorough with this case. Please follow such cases and definitely they will be useful in your practice. So please cite this case as BMT, Bhavani MAHILA Trust, Pedakakani, Guntur district versus the Gram Panchayat, that is state of AP. Right? With this, I am concluding. Thank you very much.